Please be seated. Good morning, and welcome to the Washington State Supreme Court. Today is Thursday, October 30th, and the court is hearing one case this morning. Before I call counsel, I want to introduce our pro tem judges. Due to recusals, we're joined today by 6 pro tem justices. To my right, Judge John Cooney from Division III of the Court of Appeals, Judge Elizabeth Burns from King County Superior Court, Judge Paul Thompson from Snohomish County Superior Court, and to my left, Judge Rob Lawrence Berry, presiding Chief Judge of the Court of Appeals in Division III of the Court of Appeals, Judge Megan Murphy, Division III of the Court of Appeals, and Judge Andrew Toynbee from Lewis County Superior Court. We want to thank you for your service in participating in this case. Counsel, I have Ann Bremner opening for 16 minutes, response by Tara Heinz for 20 minutes, and 4 minutes reserved for rebuttal.
Actually, I'd like to change that, Your Honor, to 3, reserving 3.
3 minutes reserved for rebuttal. And you may proceed. Thank you.
Good morning. May it please the court, and let me first say, may it please the court and my client, Tracy Flood, and counsel. I want to thank everyone for being here today. It's a very important case. Last time I was here was in 2010 in Judge Judy Eiler's case, a demeanor case, very similar to this case, but I'll talk about it in a minute. But Tracy Flood is somebody who has served the bar and the bench admirably for a long time. She's been on the Board of Governors. She has been a judge. She has received the Vanguard Award by Washington Women Lawyers, the highest honor she received from Lauren Miller, the Minority Bar Association. She's on the board for hospice in Kitsap County. She's been the representative for women lawyers in Kitsap County. She was in the Navy. She joined at 17. Her mom had to sign for her because she wanted to get an education. She worked at McDonald's. She worked her way through the military, ended up, where else? In the Navy, Bremerton. And during the time that she's been practicing, which has been now 20 some odd years before she took the bench, she's just done incredible things like I just talked about, and that is not an exhaustive list by any stretch, and we've covered a lot of that in our papers. She worked as a public defender. She has worked in hospice care. She took care of her brother. She got advanced degrees for that, to take care of her brother who had a stroke. She also has worked in the Department of Labor for 8 years before she took the bench. You have a declaration from a woman with whom she worked who said she was a delight. She never had any issues with anybody, not with peers, not with supervisors, not with litigants, not with the public. For 8 years. She has an unblemished career up until this case, with the bar, on the bench, or anywhere else. She's been featured on the cover of Seattle University Law Magazine. She's been cited as a trailblazer in Kitsap County. She is somebody that we want to embrace in our community, and the public wants to embrace. We have a right to fair trials. We have a right to fair judges. We don't have a right to perfect trials. We don't have a right to perfect judges. But she's been a work in progress for a very long time. And I'd have to say, she's done very well. One of the things they raised in this case was whether or not she cooperated with the proceedings. She was asked for her health records over and over and over again. Those are things that we protect in the system. She gave information every time she was asked. There was some kind of a way of people looking at her as if she was not being honest about her health. Well, it reminds me, and forgive me for this, Tracy, but of the tombstone that says, I told you I was sick, because she has non-Hodgkin's lymphoma. So there it is. Even when we put that into the record, they moved to strike it. It's something that she cooperated with fully. And here we are today with all the health concerns she has, with having been accused of not cooperating. And of course, she entered a stipulation as well. She didn't have to do that. A lot of these cases, as you know, go to hearing, full hearing. She signed on a stipulation, and you know what it said? It said there were not scores of people that left. There were not whole slates of employees that left Bremerton because of her. That's false. And the stipulation itself says there was maybe 4 or 5. And what it comes down to, which is incredible when you look at all kind of the sound and fury of this case, one of them was she couldn't get in the Zoom room to run court that was by Zoom. This is all during the pandemic. She's upstairs. She comes downstairs and says, someone needs to let me in. That's it. So maybe she was a little mad. So what? Another one was an attorney stood up to talk about a case, and the judge says, it's not your case isn't called. It's not your turn. That happens all the time, not your turn. Another one was the probation officer, Ian Cohen, said he was very upset because she asked him to correct his spelling in emails. And he said he felt upset because he's dyslexic and he can't do those kinds of things. Well, he can. It's called spell check. And all she asked him to do, and she asked him in private, and then she asked to have a witness when she talked to him about this to make sure all of it was fair. I mean, that's what we're talking about. That's what this case comes down to. These are the complaints from maybe 4 or 5 people.
Well, Counsel, could I ask you, this argument, is this by way of talking about sanctions, or are you contesting the stipulation? I'm not quite sure.
It is a little bit of both, but you're right. It is about the sanction, Your Honor. Thank you.
Thank you.
Justice Madsen. We are only here on the sanction, which brings me back to the stipulation, the stipulation was basically on the facts. And then the hearing was on the sanction. But somehow things got out of hand in the hearing, and importantly, counsel for the commission said in the stipulation and in our opening statement, we're not asking for removal. This is a stipulation. We signed, my client and I signed a stipulation on the promise that there wouldn't be a request for removal. But here we're here today where the commission is recommending to you that there be removal. When we look at the whole history that I just recounted about our judge, you have to ask yourself, how could she have gone from being so admirable, so dedicated, so well-liked, so well thought of, to become the person that they're portraying her as? And I submit to you that that's not who she is, and that's not what the facts showed. The complaint from Jennifer Johnson, who came over to the court supposedly to help, had left when she worked for Judge Leon in Des Moines. And she had been insubordinate, yelled with that judge, told that judge what to do, and then tried to sue Des Moines, or talked about suing Des Moines about her treatment there, gave no notice, a week, and then came over with Tracy Flood. There, she worked for a little while and then took a 3-week vacation. This is the main complainant in this case.
Is this someone that Judge Flood hired?
Yes.
Okay.
Yeah. So
that's interesting. No background check?
Boy, that's a good question, Your Honor. I'm looking at her, but I'll have to follow up on that, Your Honor. I mean, basically, the judge was in a position where there were issues with staff because one judge had been there for 20 years, Judge Doctor, and that had run it a certain way. When she came on, she was up, down, boss, Navy, and these people didn't like working for her. She has submitted, and I submit, that there was an issue of race in this. When Jennifer Johnson came on, Judge Flood said there's a problem with the culture here. She said it from the very beginning. And the witnesses that testified about this were famous Tyree. He's been in the system for 30 years. And he testified that he felt that she was being discriminated against based on her race. They called her by her first name. They laughed about her in the break room. They celebrated when something bad happened to her. And they were insubordinate. They didn't follow her directives. And they pushed back to her. And they didn't want her there. He felt it was a racist culture. He's a gentleman of color. And he was very upset by it. He said that he wouldn't even sit with these people because of the way they treated her. I mean, this is what she walked into and dealt with. Another witness Kiara Ballett, who's also a woman of color, getting her PhD right now at SPU in forensic science. She said the same kinds of things. That's what she saw of the way these people were treating the judge. Calling her Tracy, laughing about her, telling her she didn't know what she was doing, wanting to be collaborative. She's the judge. I mean, they need to work with the judge, as you know, as opposed to running the show, like tail wagging the dog, kind of speaking. And she said, when I asked her, how do you feel about this prosecution from the commission? She said, I think it's ridiculous. The issue of race, this court issued an open letter in 2021 stating it's a moral imperative to look at unconscious bias, to look at microaggressions, to look at how we deal with those members in the judiciary, in the public, in our courts, people of color. This is a case that certainly requires that scrutiny. This court also in the Henderson case, as you well know, a civil case where the litigant in a car accident case, the plaintiff, was basically characterized as an angry black woman. You know, that kind of tone policing. And also the jury didn't want to have her there when they came back with a verdict. And so she got a small award and she appealed and she came to this court, and rightfully so, this court found that if race is raised, then the burden goes to the other side to rebut that. There was a stipulation here about racism. I mean, it's docket number 121, that there was racism that my client battled in the court, and that this is a lot of why she's here, and yet the commission said there wasn't any. I don't know if they read the stipulation or not, but the fact was that there was huge issues of race for her. The court proceedings where they say that there were, where she acted inappropriately, there's no tapes, there's no transcripts. The Eiler case, which was my case here in 2010, is the only demeanor case I'm aware of in Washington State, true demeanor, which this case is.
Counsel, you said that earlier, that it's a demeanor case, but it's more than that, isn't it? Because of the warrants, for example, and the cases that, or the records that should have been forwarded to other agencies. So it's more than demeanor, which Eiler was only demeanor.
Thank you for that, Your Honor. They never had any nexus in this case that that was her fault. There was never any evidence in this case that that happened. That's from one disgruntled lawyer, Gary Hersey. I'm going to play a tape of him right now, saying that things were in disarray. Phones weren't being answered. How could she control that? Certain paperwork wasn't going through. How does she control that? She's being undermined.
Well, counsel, I thought that there was at least one person who stayed in jail because the paperwork wasn't completed by the judge. I think that's verified.
Well, that would be something that wasn't submitted in time. I mean, and she's got running a court all day long without any ability to deal with what's happening with all the paperwork. But I would concede if that was true, that would be very concerning, but it's not the case. And she didn't testify to that. And so we're dealing with a very small group of people that were out to basically try and undermine her.
Can I ask, going back to the stipulation, and then I think that I think it was under a competence and diligence charge, which was under standard 2.5A. And one of the arguments was that implicit or included in the stipulation and the commission's acceptance of the stipulation was that the charges would be what you've characterized as the demeanor charges. I don't remember the standard numbers, but not the 2.5. Could you address that, whether that charge or consideration of a competency, diligency shortcoming was properly in front of the commission?
Thank you, Your Honor. Justice Stevens, I think that it clearly wasn't, and the stipulation stated that it wasn't. And we addressed it up front saying that it shouldn't be. And yet it was part of their part of their findings and should not have been. Again, if you enter into a stipulation, then you have to rely on the promises that were made in connection with that stipulation and going forward. Otherwise, we wouldn't have entered into that. So it shouldn't have been.
Well, Counsel, was there anything in the stipulation that provided that the 2.5A charges would be dismissed?
The stipulation didn't include the 2.5A.
Well, one could then stipulate to part of a case and not the other part, and then the remaining, which was not stipulated to, would have to be a finding, based on findings.
That's right, Your Honor, except for in this case, because in this case, the stipulation said we're dealing with everything except for the sanction in the stipulation. So it wasn't in there, and it shouldn't have been part of the case because of the way the stipulation was worded.
At the end of the day, Counsel, what are you asking us to do? Given the nature of the stipulation, the substantive violations, as I understand it, are not directly at issue. And instead, we're, I think, focused on the appropriateness of the
Yes.
Commission's sanction recommendation. So my question is, what do you want us to do?
I wouldn't ask me that, Your Honor.
From no sanction to suspension to removal. Where are we?
You know, I actually think it should have been a reprimand, and that's what all of the demeanor cases are, and that's what the Eiler case said. They're all, at worst, reprimands. But at this juncture, where we are, Your Honor, Justice Johnson, is that we're asking that there be the censure that's been entered. That is what we stipulated to, and then call it a day. Because, and that's far more than she should have done, in my opinion. But, you know, she's got health issues. This has been a horrible situation for her family. And she's still willing to go back. She's still willing to be a judge, which brings me to another issue in this case. They say that she's not coachable. They say that she had people come in to help her, and that's not true. Jennifer Johnson and another clerk came in to do some help with staffing, scheduling, etc. That's it. And then at the end of the day, there was an individual in Kitsap County, I keep forgetting her name, that there was an individual in Kitsap County who admirably agreed or asked to help. She saw an article about the judge in the Kitsap Sun about this case. And so she called the mayor and she said, "Can I talk to her? I'd like to help." That's it. They met. The judge actually cried, just like when she met with Jennifer Johnson and said, "There's a culture here." But there was no help there. So that's what they're relying on, saying that she's not coachable.
I also thought that Ms. Kinlow came in to do some coaching, and her testimony seemed to suggest that it appeared that Judge Flood was amenable, but then didn't follow through on recommendations. And Ms. Kinlow, I think she had, 25 years of experience. So, I mean, clearly it wasn't just to come in and be an assistant. It was there for coaching, wasn't it?
Yeah, Your Honor, Justice Manson, that is true, and that is her name, and that's the one I mentioned that came in with Jennifer Johnson. It's very limited, and no coaching in terms of how to run a court or how to deal with your staff or anything else. So it's very, very limited, very, very vague, but not coaching where she's basically refused to listen and refused to get better, because she's always wanting to improve, as you can see from her career, including how she's handled this. So I wanted to play.
I do want to let you know, counsel, that we're into your rebuttal time now. So you
Thank you.
deserve 3 minutes.
I do have a tape, and thank you. If I can just answer or address this tape really quickly. It's Gary Hersey, and it's a session he described as where she was discourteous, terrible demeanor, etc. It's Exhibit 340B. I urge you to listen to it. Her tone is absolutely appropriate. He struck a jury when he shouldn't have, as a lawyer. She said he couldn't. She never raised her voice. She heard him out, and she had a hearing. And that's the exhibit, and that's the best evidence. They had no other tapes, no transcripts, nothing about her. This is the one. Thank you.
Thank you, counsel. Response, please.
Chief Justice Stevens, may it please the court. Tara Heinz, Deputy Solicitor General, appearing on behalf of the Washington Commission on Judicial Conduct. Serving as a judge is a sacred public trust. Judge Flood violated that trust and the Code of Judicial Conduct by belittling, criticizing, and demeaning her own court staff, causing her staff and her single judge municipal court grievous harm. Staff members suffered depression, anxiety, panic attacks, and even contemplated self-harm before they left one by one in self-preservation, leaving the court unable to complete court essential functions. And despite working with multiple self-chosen coaches and experts, Judge Flood has demonstrated neither the motivation nor the capacity to stop this damaging pattern of misconduct. The Commission asks this court to affirm its unanimous decision and recommendation to censure Judge Flood and remove her from office.
Can I ask about that recommendation? Because in the stipulation, and I'm reading from paragraph 7 on page 10 of the stipulation, the parties agree that the case will proceed to hearing on the issue of sanction. Disciplinary counsel agrees that censure with removal will not be recommended, but you are recommending that today.
That's right, Your Honor, and that is just disciplinary counsel. She made very clear in the colloquy at 42 and 43, 47 and 48, and 55 and 56 that there was no stipulation, 1, with respect to 2.5, but 2, that the Commission, of course, retained full authority to determine what the appropriate sanction was. She herself was not going to recommend removal, but the Commission, of course, had a determination to make about what the appropriate sanction is. And of course, this court, neither the Commission nor this court is bound by the stipulation. They have the constitutional duty to evaluate the evidence, to consider the Deming factors, and determine what the appropriate sanction is. And the goal of the sanction is twofold. 1, and this is in CJC Rule 6D, it's to determine what sanction is appropriate to restore integrity to this courthouse, restore dignity and honor to the court, and what sanction is necessary to ensure that misconduct does not occur in the future. And what the Commission found is that the misconduct at issue in this case was one of the most serious issues of misconduct in terms of harm to both individuals and to the court functioning that it had ever encountered in its history.
So, counsel, as a practical matter, in practicalities may not come into play, but I understand this is an elected position, and this is the year for election, and Judge Flood has not filed for another term.
She has not filed for another term.
So her current term expires at the end of the year or whenever the term otherwise would expire. So practically speaking, if it took us, what effect does your recommendation of removal have if she's already gone? Does it essentially become a moot sanction?
It becomes moot only with respect to the current situation, but I do think it's very important with respect to restoring dignity and honor to the court. Court staff are certainly around the state watching this case. They're wondering whether they matter. They're wondering how many lives can be upended before there's some accountability. And particularly in this case. In most other cases, when judges have stepped down, they have taken responsibility for their misconduct, they have owned it, they have expressed remorse, they have expressed regret, and they have promised not to seek judicial office again without permission from the Commission. So that is why the sanction of removal is still necessary here, because Judge Flood has not shown any accountability, despite stipulating to egregious acts of misconduct, or stipulating at least to misconduct. When she was asked at the hearing about whether she had ever been discourteous to any individual, she denied it. She went through all of the evidence, all of the facts in the stipulation, and essentially denied that she had ever been rude. And the evidence in this case was incredibly compelling. There were 6 individuals that provided direct testimony against her, including 3 court administrators and an interim court administrator, that 3 of them had left during her very short tenure, and her then current court administrator was actively seeking another job. And they attributed this specifically to conduct by Judge Flood.
Can I just pause and ask you, it's very difficult reading this record to not see all that is there, to just see one side or all that is there. I mean, nobody else is being accused of misconduct here, but there was a lot of chatter among some counsel and staff that was grossly inappropriate in terms of respect for a judge, making fun of a judge, demeaning a judge, mocking a judge. That behavior is there. Is it your position that there's nothing in this record that would indicate bias or tone policing or the effect of race in the way Judge Flood and staff interacted?
Certainly not, Your Honor. The Commission understands fully and acknowledges that racism is real, implicit bias is real. It almost certainly impacted Judge Flood, both in her time in office and her efforts to seek office. That is something that the Commission does acknowledge. And when she came forward with these allegations in the very beginning of this process, the Commission stopped its public process. It went back to the investigation phase. It spent 5 months investigating the allegations that the specific complaints at issue here were rooted in racial bias. And ultimately, Judge Flood did not come forward with any instance of implicit bias or overt microaggressions or macroaggressions other than the single individual who has been unnamed so far who called her by her first name. That was the one instance. The Commission also considered the testimony of Latricia Kinlow, who is a Black court administrator with decades of experience who came to the courthouse at Judge Flood's invitation. She had been told that by Judge Flood that the problems she was facing were rooted in racial bias. And so Ms. Kinlow came looking for microaggressions, looking for macroaggressions, looking for anything that would support what Judge Flood had said. And what she found was nothing of the sort. That was her testimony. She testified what she found was a hardworking staff that was overwhelmed. They were doing 3 jobs at once, and they were being serially mistreated by this judge. Latricia Kinlow actually witnessed these events. She said that they were things that she had never seen a judge do in her 30 years or decades as a court administrator.
Well, counsel,
she said,
the coaching that you're just referring to by Ms. Kinlow is not a judge.
that's right, she's a court administrator.
Right. So what effort was made to offer coaching to Judge Flood from another judge with experience in a one-judge court, which has to be very challenging when you follow someone after 28 years in the position and apparently well-loved?
Certainly, Your Honor. There were 3 efforts at coaching Judge Flood, and it was primarily an issue with dealing with staff. Like, her treatment of staff was the primary issue that was involved here. And so there was coaching by Latricia Kinlow, and Latricia Kinlow made very clear that this was not just an issue of tone. This was serious mistreatment that she witnessed. And this was not a staff that was showing implicit bias or the type of racial misconduct that has been alleged here. But Latricia Kinlow gave those the suggestions about how court functions could be improved. So what Judge Flood was doing that was bogging down the processes, and she testified that Judge Flood rejected them all. Maurice Baker was another individual who had 30 years of experience as a court administrator, who came in voluntarily 8 to 9 hours a day to provide Judge Flood, advice and deal with the court staffing crisis, because ultimately what happened is virtually everybody left this courtroom. So they were trying to figure out how to improve the relations with court staff and how to improve court functions so that the harm to the court that had happened would no longer occur.
Can I just jump in, though, and make sure that the 2 individuals, in response, Justice Madsen's direct question was, it is unique to be what we sometimes call a PIP, presiding in perpetuity, single judge in a single court, especially coming into a situation after a long tenure, different culture under a different judge. Can you speak to any other, judicial mentoring or coaching? Because I think, to some extent, those court manager consultants were brought in to just deal with trying to get the court up and running because, of situations, which I think even in your briefing you acknowledge can't all be laid at the feet of the judge alone.
Certainly.
There were many problems because of attrition and other issues.
Understood, Your Honor.
So
there was
any judge.
There was not a judge. But what commission staff during the investigative process, during the time period where they went back to investigate the charges of racial bias, the commission staff worked with Judge Flood. They asked her to find a coach of her own selection. She should be able to choose the coach to be able to work through some of these issues. And she chose an executive coach. And that person, Judge Flood, stipulated that even after working with the person that she chose to help her, that her misconduct continued and court departures continued. That's at paragraph S of the stipulation.
Counsel, can I ask you about, I mean, we're talking right now all about Judge Flood, but it wouldn't surprise me at all that staff needed implicit bias training to understand its own reactions. Was that offered to the staff?
That's not in the record, Your Honor. I'm not aware of whether that was offered. And you know, I think what is really at issue here is that Judge Flood was not receptive to input from anybody who was offering to help her, people that she had invited into the courtroom. Maurice Baker worked for 3 months, 8 to 9 hours a day with her, giving her different types of suggestions. And while he said initially she seemed receptive, that she reversed them after a period of 3 months. She left him a letter on his desk reversing almost all of the things that he had suggested with no explanation. And so what's being described here is interactions with court staff, treating staff in ways that are not humiliating and belittling to them. And I do want to go back to that treatment because it was very significant, and we're not just talking about a handful of people. 6 court employees and former and current employees testified about the experience that they had. They suffered panic attacks. One court administrator, an interim court administrator, contemplated walking into traffic. Other court staff testified that they saw her regularly trembling at her desk. Another probation officer who had worked with the court system for 22 years at Bremerton Municipal Court. He had won 2 awards as Probation Officer of the Year. He became so despairing, he had to take sleep medications. He stopped sleeping at night, and his wife would find him lying on the floor of his garage. We're talking about serious mistreatment with serious psychological impacts. But there was also...
Could I ask you about the training of the members of the commission who arrived at this recommendation? Have they been through implicit bias training?
Yes, Your Honor. Okay. That's not in the record, but yes, absolutely, they have.
They saw nothing here.
No, that's not true, Your Honor. Absolutely. The commission acknowledged that there is racism, that it is real, that this almost certainly impacted Judge Flood. But ultimately, there was not an explanation here that bias was the reason for this misconduct, and it could not excuse the continuing misconduct, particularly given that Judge Flood would not acknowledge that she had engaged in the misconduct, notwithstanding the stipulation. At the public hearing, when she was asked by her own counsel, have you ever been discourteous to anyone, to any attorney, to any staff member? She said, no, I haven't. I don't believe so. I have always been judicial in my manner. And so all indications are that if she were to be returned to the bench, that she would engage in the same level of misconduct. And it was significant.
Well, counsel, before you go back to that, we heard the litany of accomplishments that Judge Flood has under her name, including working well with many, many other groups and organizations, many of which I recognize, you know, in terms of them being judicial organizations. How do you, I guess, determine from that part of her history that she is incorrigible and that she cannot be rehabilitated in terms of her ability to handle a one-judge court, for example?
Well, Your Honor, none of that was presented as evidence in this case. What was presented as evidence was that she had been part of a voluntary board recently and that she faced the exact same allegations there of creating a hostile environment, of belittling her co-board members. And so the commission also took that into account in assessing credibility, that her continued denial that she had ever engaged in mistreatment here. The fact that she had been accused of the exact same type of mistreatment and misconduct on a board on which she recently served. And so the part about having had all of the accolades, we don't deny that there are many accolades, and Judge Flood has done well. What she hasn't done well here and what she has engaged in here, though, is very serious. Court staff need to know this is the process to protect them. This is the process to ensure that they do not get serially abused without accountability, without recourse. And part of the problem with Judge Flood's lack of cooperation with this process is it became very extended. These people had an unduly unfair burden placed on them in participating in the commission process. They tried to go to the Bremerton City HR department. They tried to report their complaints. They tried to speak with her directly about the things that they were facing. Judge Flood threatened to sue. She shut down the HR investigation at the city of Bremerton. So this is really the only recourse. And the fact that it took more than 2 years to obtain a result here, if she were to be returned to the bench, how could the commission expect anyone to come forward in the future, given the burden that was placed on the complainants in this case? Ultimately, it's not a determination of incorrigibility. In the Ritchie case, the court said that the very fact that the judge refused to take accountability, refused to acknowledge the wrongdoing, was itself a strong indication that the misconduct would continue, that it was a very serious violation, it was a pervasive violation, just like it was here. This was pervasive. This affected many people, not just the 6 people who provided direct testimony, but as well.
I need to pause because Ritchie, I mean, understanding that absolute denial that anything was wrong weighs heavily.
Certainly.
We have a stipulation here. It went to the commission. The stipulation is to demeanor violations under, I'm sorry, I'm not going to find the numbers of the standards. So you have to look at that in toto, wouldn't
Yes.
you agree? So that it's
Yes.
not that there's no, and I also read the stipulation to say that Judge Flood agrees that she would engage in further coaching and training and remedial steps.
Certainly
Don't we
not.
have to take that as part of her acknowledgement?
Yes, Your Honor, I do think that that is part of it, but when she was asked by her counsel, she went through each of the aspects of things that she stipulated to, and then denied most of it. And so this was not a wholehearted commitment to change. It was not a wholehearted acknowledgement. It was not an embrace of future with protective mechanisms to ensure that there would be future accountability or some prevention for future misconduct. When she was asked under oath, what do you think? Do you think you engaged in this misconduct? She made very clear that she did not. She did not think she had ever even been rude, let alone discourteous. She expressed no remorse for the impact, the very harmful impact on all of these very long-standing public servants. Most of the people who had worked at this courthouse had worked there for more than a decade, and many left under extreme psychological duress. And I think that's very important. There are people who worked there for 20 years. They left on medical leave and did not return. They filed an HR complaint and then they were retaliated against by the judge. That's at Jennifer Johnson, Volume 2, 130, as well as the Exhibit 122. Marita May is another individual that Judge Flood herself hired. She left for lunch and never returned. She sent an email resigning effective immediately, and other witnesses like Stephen DeRosier said that Judge Flood had regularly made her cry. I mean, these are people who trembled at their desk because of this mistreatment. Jennifer Johnson testified that the judge would call her in to witness the humiliating and belittling of Ian Cohen, of Stephen DeRosier, of Brian Knowles. These are people who worked for this court. They devoted their adult lives. And court staff around the state are looking. Does this matter? Is there going to be accountability here? Will they be protected? And the commission determined they looked at all of this evidence, and they looked at the 2 factors that you need to consider when determining the appropriate sanction. What is necessary to restore integrity to this court when you have a judge, despite her stipulation, denying that she has ever even been rude to an individual, let alone cause panic attacks, cause her employees to lay on the floor of their garages, think about walking into traffic because of the way she berated them? She did not acknowledge any of that. She wouldn't even acknowledge that she had been rude to anybody. Latricia Kinlow testified that she had arranged for 2 remote clerks to support the judge. And even then, those remote clerks were so uncomfortable with the way that Judge Flood treated counsel in her courtroom that they asked to stop providing that service through court helping courts. I mean, you have a very significant, pervasive pattern of misconduct. Given the egregious harm to individuals and the court's essential functions here, as well as Judge Flood's failure to take accountability for that harm and her unwillingness to change, the sanction that would restore both dignity and honor to the court and protect court staff from future misconduct is to censure Judge Flood and remove her from office. We ask the court to adopt the Commission's unanimous decision and recommendation in full.
Thank you, counsel.
Thank you.
Rebuttal, please.
First of all, of course the judge admitted to the misconduct. She signed a stipulation. And in her testimony, the questioning from Commission counsel was on Zoom, very direct, and not showing the stipulation to my client. So my client would say, that's what I stipulated to. That's what I said I did. She didn't deny. She's like, I know, I signed it. That's what I said.
Well, counsel, is opposing counsel misrepresenting the record? Because it didn't seem that it was misrepresented.
No, Your Honor, Justice Mattson, the way that I see it, and I was there, was that I objected, asking that it be shown to her. And probably that was my fault for intervening and saying she needs to see it. And then, of course, she wasn't given it. So it kind of repeated that way. But it wasn't a denial. It was my fault. I object too much sometimes.
Well, I guess what I'm wondering is, the picture that the record seems to suggest on the one hand is a denial that, there's a stipulation that says I admit it, but then there's testimony that seems to say I deny it. That's very hard to reconcile. How do you...
Understood, but that was my fault, as I said. She was not denying it, for sure. She went through that whole hearing, she stipulated. The Eiler case, I'm almost out of time, dealt with demeanor exactly like this. They said a sanction of reprimand is appropriate in a case like that. They only went to censure because she'd done it before. Finally, when I tried that case or had that case, Justice Sotomayor was up for the Supreme Court. You know what they said about her, a woman of color back then? She's a bully, she's a terror on the bench, she's aggressive, and no one likes to be around her. And I used that in my argument here. It's demeanor. All the demeanor cases, they don't result in removal.
What did your client ask for in the way of assistance? Because it had to have been clear this is not the way courts operate. So did she have some responsibility to ask for help, and what kind of help would that be if she, because you're saying she should be allowed to go back on the bench. Well, I'm not sure that we would see something different, would we? And not just from her, I'm just saying broadly.
And I know, Your Honor, that you served as a municipal court judge, just like she did, if I'm not mistaken. I've been around a long time, but I think that she was basically in the sights of the commission from the get-go. Her folks in the court were going behind her back and going to the commission. The commission was reaching their hand into her courthouse. And so at that point, she was like a deer in the headlights, trying to survive, trying to make sure everything's okay. She would always say to people, are you okay? Are we okay? Trying to just function. And so asking for help, I don't even know where you asked for help, but she was amenable to help. She talked to people who said they would help. I didn't see the commission coming in, helping her in any way. It was only hindrance up until now, including when they said, let's have a stipulation, they still asked to remove her when she was trying to do the right thing. And the stipulation talked about just that, getting help. Thank you.
Thank you, counsel. The court wants to thank both counsel for your arguments this morning. This case is submitted, and the court is in recess until 1:30.
Supreme Court is in recess.